Hello, everyone. Thank you for joining us. While we wait for more folks to get on, I'm going to put a poll up. We'd love to know where everyone is joining us from. So if you could take a few seconds while we wait for people to log on, we'd love to know where you're joining from. All right, we still have more people joining, but we will go ahead and get started. Good afternoon. My name is Selena Damian. I am the student loan ombudsperson in the state of California. I'm based out of the California Department of Financial Protection and Innovation. We are the state's consumer protection agency. Before we get started, I want to go over some housekeeping items. Throughout the webinar, your video, microphone, and chat feature will be disabled. Due to the amount of participants today, we do not have a Q&A function, but we will provide our contact information as well as others' contact information and resources at the end of the webinar. This event is being recorded and it will be available on the DFPI YouTube channel within the next 24 hours. A copy of the presentation will also be emailed to all registrants. We know that things are ever changing, but the information provided today is accurate as of today. I'm going to go ahead and end the poll now. Katie, next slide, please. First, I want to thank everyone for joining us this afternoon. We hear from borrowers every day and know that these are extraordinary times that are creating considerable obstacles and confusion for many of you. We recognize the challenges in trying to obtain forgiveness, PSLF, IDR forgiveness, enrolling in affordable payment plans, and just obtaining accurate information. Ongoing legal challenges, upcoming changes in the student loan system, and a reduction in the workforce at the Department of Education have further complicated those issues. Following years of advocacy initiatives, states have recognized the importance of providing support at the state level and have established their own student loan protections. By leveraging established consumer protection laws, states are holding servicers accountable and they're protecting vulnerable borrowers. Currently, 18 states have implemented requirements for student loan servicing or have established a student borrower bill of rights. And in some states, like in California, we have both. Many of these states have created positions similar to mine. These roles are situated within various state agencies and may possess differing authorities depending on the state. Nevertheless, we all share a common objective, which is to advocate for borrowers and offer reliable and up-to-date guidance to assist them in managing their student loan debt. Our initiatives require collaboration with our own agencies as well as collaboration with each other. It is my pleasure to be joined today by ombudsmen and advocates from Nevada, Washington, Minnesota, Illinois, Washington, D.C., Oregon, and Maine to bring you up-to-date information. Whether you're a student, a borrower, or an advocate, or a parent, we hope you find this information beneficial and thank you again for joining us. This is our agenda today, and I will hand it off to Evelyn to get us started.
Good afternoon, everyone. My name is Evelyn Castro, and I am the Student Loan Ombudsman for the state of Nevada. In the next few slides, I'm going to give a general overview of or on student loans. On this slide, I want to ground us in the scale of the student loan landscape in the US. Right now, total student loan debt sits at about 1.8 trillion, making it one of the largest categories of consumer debt, second only to mortgages. This isn't impacting a small group. Over 42 million Americans currently have student loan debt. That means this issue touches nearly every workplace, community, and family. On an individual level, the average federal student loan debt is just under $40,000 per borrower. For many, that's equivalent to a car loan or even a down payment on a home. These numbers help explain why student loans are not just a personal finance issue, but a broader economic and workforce issue. As we move forward, keep these figures in mind. They highlight why understanding repayment options, forgiveness programs, and recent changes is so important. Next slide, please. Now let's break down the two main types of student loans, federal and private, because this distinction really matters. Federal student loans are funded by the government, specifically the U.S. Department of Education. They tend to be more flexible, offering fixed interest rates, income-driven repayment plans, and options like deferment or forbearance if someone is struggling financially. They also come with potential benefits like loan forgiveness or discharge programs, which we'll talk about later. On the other hand, private student loans are issued by banks, credit unions, or other private lenders. These loans typically have fewer protections, repayment options are more limited, and forgiveness or discharge is usually not available. Interest rates can be fixed or variable, and approval often depends on credit, sometimes requiring a cosigner. One really important takeaway, if a federal student loan is refinanced into a private loan, those federal protections are permanently lost. So understanding what type of loan you have is critical before making any decisions. Next slide, please. Before we go further, it's really important to understand who the key players are in the student loan process. First, the borrower. That's the individual who took out the loan and is responsible for repaying it. Next, we're going to skip over to the lender. This is the entity that actually provides the money and sets the terms of the loan. For federal student loans, that would be the U.S. Department of Education. Then we have the servicer, which is pretty much like a middleman, because this is who the borrowers interact with most on a day-to-day basis. Servicers handle things like billing, processing payments, and helping borrowers change repayment plans. So even though the Department of Education is the lender, borrowers typically don't work directly with them. They'll work with through the servicer. You might recognize some of these servicers listed here, like Advantage, Mohila, or Nelnet. Understanding the difference between a lender and a servicer is key, especially when borrowers need help or are trying to resolve an issue. Next slide, please. Now let's talk about repayment options for federal student loan borrowers, because this is where borrowers have some flexibility. The standard 10-year plan is considered the default for federal student loans. What that means is if a borrower doesn't choose another plan, this is the repayment schedule that will automatically apply. It's simple and predictable. The payments are fixed every month, and if you make all of them on time, the loan is completely paid off in 10 years. One of the benefits of this plan is that it usually minimizes the total interest paid over the life of the loan, compared to the other plans that extend the repayment period. That said, because a loan is paid off faster, the monthly payments can be higher than some of the other options. Second, you have the extended plan, which stretches repayment out up to 25 years and can lower monthly payments. The downside is that because the repayment period is longer, borrowers usually pay more in interest over the life of the loan. It's important to note that this extended plan is being phased out for new borrowers, so it will no longer be an option for anyone taking out loans going forward, beginning with new borrowers, with loans dispersed on or after July 1st, 2026. Then there's a graduated plan, which starts with lower payments that increase every couple of years. This can be helpful for borrowers who expect their income to grow. And then finally, there's the income-driven repayment plans, often called IDR. These plans base your monthly payment on your income and family size, making them one of the most flexible options. After a certain number of qualifying payments, any remaining balance may be forgiven under IDR plans. Currently, IDR plans include the Income Contingent Repayment Plan, which is known as the ICR, Income-Based Repayment Plan, known as the IBR, and Pay As You Earn, which is PAYE, also known as PAY. The SAFE plan has also been part of the IDR plans, and the REP repayment assistance program will also be part of this in the near future, which will be discussed later in this webinar. The key takeaway here is that borrowers have options, and choosing the right plan can make a big difference in affordability and long-term costs. And with that, I'm going to turn things back over to Selena Damian, California Student Loan Servicing Ombudsperson, who will briefly speak on borrowing limits.
Thank you, Evelyn. I'd like to discuss borrowing limits and the changes that are taking place effective the 2026 academic school year. As a result of 2025 legislation, significant changes are coming to financial aid and student borrowing. There are no changes to undergraduate limits. Start off with that. Those limits will remain the same. However, significant changes are coming for Parent Plus borrowers and graduate borrowers. Currently, Parent Plus borrowers are able to borrow up to the full cost of attendance for their dependent undergrad students. Starting July 1st, 2026, borrowing for new students, new borrowers will be capped at $20,000 per year per dependent student with an aggregate total of $65,000. So if you look at the numbers, $20,000 for the 4 years is more than the 65,000. So essentially what this means is you will have to you have a limit of 16,000 per year if you're trying to borrow equally for the entire 4 years. So the aggregate total is 65,000 per dependent student. Elimination of the Graduate Plus program, that's also happening July 1st, 2026. There is a caveat to that. Existing borrowers may continue borrowing under current rules through a legacy provision for up to 3 years. So as long as you are remained in the same program and you have already borrowed for the program, you will be able to borrow under the current rules. For example, for a Parent Plus borrower, if you have a child who is at their senior year, starting the academic school year of 2026, and you've already borrowed for the previous 3 years, you will not be subject to the new rules. However, if you have a new student starting the academic school year, then you will be subject to the new rules. Same thing for Graduate Plus borrowers. As long as you remain in the program, you will still fall under the previous rules. The Department of Education has also split into two tiers, graduate programs and professional programs. So graduate programs include master programs and some doctoral degrees. They will now be limited to 20,500 annual limit and a lifetime borrowing of $100,000. Professional programs, these include careers that require highly specialized degrees. So we're talking about doctors, lawyers, and these are typically professions that require a professional licensure. They are now limited to 50,000 annual and lifetime borrowing of $200,000. There is also an overall lifetime borrowing limit of 250,500, and this applies to all federal loans, undergrad and graduate, and this amount will remain the same regardless of if you paid off some of the balance or received forgiveness. And this borrowing limit does not include Parent Plus borrowers. What does this mean for borrowers? We don't know fully yet, but it definitely means that borrowers will have to start looking at other options, really sitting down and doing financial planning for their schools. This could be, it could mean that borrowers now will be turning to more institutional loans or private loans. As Evelyn mentioned in the previous section, private loans have different terms. It has nothing to do with the Department of Education. These lenders are setting their own terms. So it's very important that you understand your options and you do your planning. Private loans and other type of financing will require an established credit history, possible co-signers. So it's really important that you understand that. Now I will hand it over to Margaret.
Let's see. Hi everyone. My video is, there we go. We've got it. Hi everyone. I'm Margaret McWhorter. I'm Illinois Student Loan Ombuds. My position's housed in our Attorney General's office. I'm going to briefly talk today about the Federal Student Loan Repayment Plan, known as the SAVE Plan. What is the SAVE plan? Well, it's an income-driven repayment plan. It's short for Save on a Valuable Education. A rule and the negotiated rulemaking process created the SAVE plan. More than just the SAVE plan was part of that rule. SAVE is essentially a modified version of repay. But it allowed for faster forgiveness for lower balance borrowers, more affordable monthly payments on undergraduate loans. If you were in repay, you automatically got moved into SAVE in the summer of 2023. Currently, there are 7 million borrowers enrolled in SAVE, and was the subject of an ongoing lawsuit. Next slide. Okay, a lot of information on here. I'm going to hit on the key points. There was a lawsuit, some states sued about the SAVE plan in the summer of 2024. If you were in the SAVE plan, because of the lawsuit, you got put into an interest-free forbearance. So for roughly 7 million borrowers, you didn't need to make payments, but and your loan balance wasn't getting any higher. But that time that you were in the forbearance or are in the forbearance isn't counting towards income-driven repayment forgiveness, isn't counting towards PSLF forgiveness. And the forbearance is still going on. But on August 1st of last year, interest started accruing again. Then in December, the Department of Education and the states that were suing about the SAVE plan came to an agreement about ending the SAVE plan. And then nothing happened for a few months, and now we have a flurry of activity, a little bit of whiplash. At the end of February, the court just dismissed the lawsuit, didn't rule on the merits, said it was moot, but then the suing states appealed that dismissal. The appellate court said to the lower court, all right, enter the order, enter what they agreed to in December. And the SAVE plan ended. That order was entered. Like I mentioned, more than just the SAVE plan was in the rule that created the SAVE plan. That all ended too, but I've got one exception there. It's different deferments and forbearance, I think 11 kinds, like cancer treatment deferment, military service deferment. Those will be allowed to count towards IDR forgiveness. It just wasn't part of the lawsuit that was challenging it, so that part still exists. All right, so litigation was over, but then is over, but then last Friday, a group who had not been part of the lawsuit before says, hey, we want in on this lawsuit, we want to intervene. Also, please reconsider the ruling that you made. All right, so we don't have a crystal ball. Pretty clear with all of this whiplash going on, it would be nice to have one. We don't have a crystal ball. We don't know what's going to happen with those motions to intervene or reconsider. Maybe there would be other possible litigation. We just don't know. But right now, that March 10th order stands and SAVE is over. And for now, and next slide, please. So what does it mean? If SAVE is over, you need to prepare to change plans. That doesn't mean change plans today if you don't want to, but prepare for those next steps. Think about your goals. Are you looking for forgiveness through an income-driven repayment plan? Do you want to start making payments again and have that time count towards forgiveness? Are you a public servant hoping for public service loan forgiveness and you're planning on using the PSLF buyback, so maybe you're going to wait and to buy back these months, or maybe you're really close right now and you just want to get it over with and get back into repayment. Are you looking just for a low monthly payment? Do you plan on not getting forgiveness but eventually paying off your balance? And it is entirely valid if you want to ride this SAVE forbearance out until it is totally over. If being in this forbearance, even with the interest accruing, but not having to make those monthly payments is something your family needs, that is okay. It is a personal choice. It's not one size fits all. You just need to prepare. think about what your goals are, and then check your accounts, your studentaid.gov and your servicer accounts regularly for news. Make sure that they have your current contact information. Update it, because when the department decides that everybody needs to get into a new plan, they'll be providing that update. And we just don't know how quickly that is going to happen. So you need to prepare. So make sure that they have your contact information to give you that updates. Proactively look. Because I guess a worst case scenario, if you don't choose to get into a new plan when the department gives that instruction, what if you end up in that standard 10-year repayment plan and not an income-driven repayment plan? Depending on your loan balance, that could be a much higher repayment. So you just need to stay informed, keep looking, see what's out there, try the FSA's loan simulator so you know what a payment might look like well, on the standard repayment plan or on the income-based repayment plan IBR. Are your payments possibly going to look like, and how can you prepare for when you have to switch plans? And yeah, watch out for scammers. It's free to get into a different repayment plan. If you need to consolidate a loan, that's free. You don't need to pay somebody to do this for you. If anyone is asking for your FSA ID or password, that's weird. That's bad. Don't give it to them. And if you have, change that password and report it. Yes, thank you so much. I'll send it back to Selena.
Thank you, Margaret. So I am covering for Michelle Jarvis Letman. She's from Connecticut, but is not able to join us today. Next slide, please. I will briefly be talking about consolidation because you will hear about that in the next few slides. What is a consolidation? It's converting or combining your either older FFEL Perkins loans or multiple direct loans into one direct consolidation loan. It is a free process that can take between 30 and 60 days. Many borrowers choose to consolidate because they want one single loan, one monthly bill, and they want one fixed interest rate. In the past few years, we've had a lot of borrowers who consolidated in order to access the PSLF through the PSLF waiver initiative, and then through the one-time account adjustment. Many borrowers also consolidated their loans as well. Next, please. Some things to consider when consolidation can occur with a single loan. So you can have an older FFEL loan, Perkins loan. It can be consolidated into one direct loan. If you want to consolidate an already consolidated direct loan, you must have another loan to combine with it. So if you only have one direct consolidation loan left, that's as far as you can go. Your monthly payment may go down, but your repayment term may be longer. Consolidation is similar to refinancing, so just keep that in mind. Any unpaid interest will be capitalized and added to your balance, so you may see a higher balance after consolidation. And the new interest rate on the new direct consolidation loan will be a weighted average. Consolidating your loans now might impact your counts for PSLF, and it will result in a weighted average. So this is different than during the PSLF waiver or the one-time adjustment. The time to receive full credit has already passed that deadline. So now if you're a borrower that is on the PSLF track and are consolidating various loans, you will receive a weighted average. There is a calculator available through our partners at EdCap in New York where you can determine what your count is if you decide to consolidate. And then consolidating a Parent Plus loan with a direct consolidation loan or just your own federal loans may limit your access to IDR plans. And my co-panelists will be discussing that on the next slide. So now I will be handing it over to Jessica.
Hello, everyone. My name is Jessica Manfredi, and I am the student loan advocate for Washington State. And I am going to be talk to you about several changes that are happening to repayment options that are coming in later this year and in the next couple of years that you need to be aware of. Next slide. But first, we need to go over some key definitions that will help you understand which type of borrower you are. So new borrowers are anyone with loans after July 1st of 2026. So this includes if you are in school and borrow on or after fall of 2026, if you consolidated your loans after July 1st of 2026, and if you borrow money for your dependent after July 1st of 2026. So in other words, you take out Parent Plus loans. On the other hand, current borrowers are anyone with all loans before July 1st of 2026. This means that you borrowed prior to July 1st of 2026, and you will not be borrowing for yourself or a dependent or consolidating in the future. Your repayment plan options moving forward will be different depending on whether you are a new borrower or a current borrower. Next slide. Now, let's talk about the new repayment plans that will be available later this year. We have a new income-driven repayment plan that was mentioned earlier, the Repayment Assistance Plan, RAP. This plan bases your payments off adjusted gross income, number of dependents, and tax filing status. RAP will lead to forgiveness after 30 years and will require a minimum payment of at least $10, no matter your income or family size. You will also get a $50 payment reduction per dependent. However, it's important to know that Parent Plus borrowers will not be eligible for RAP. And this means that if you are a Parent Plus borrower who has not consolidated yet your student loans, if you want to access income-driven repayment, you will need to apply to consolidate by April 1st of 2026. Now, there is also a new tiered standard plan, which will be the standard plan for any loans taken out after July 1st of 2026. And the number of years you'll be in repayment under this new standard plan depends on how much you have borrowed in total. Next slide. There are some important dates that you need to be aware of to understand your options for repayment plans. Effective July 1st of 2026, current borrowers, meaning those with only loans before July 1st of 2026, will be eligible for the existing standard, extended, and graduated plans, the income-based repayment or IBR plan, the new repayment assistance program or RAP plan, and the income contingent repayment ICR, and the pay-as-you-earn payee plans. However, it is important for you to note that ICR and payee will be phased out by July 1st of 2028. So if you are enrolled or enroll in one of those plans, you will need to switch to a new plan. Effective July 1st of 2026, new borrowers with any loans after July 1st of 2026 will only be eligible for the new repayment assistance program, RAP plan, and the new tiered standard repayment plan. So basically, new borrowers are going to have fewer options for repayment, less flexible options for repayment as well. Parent Plus borrowers will only be eligible for the new tiered standard repayment plan. Next slide. In a couple of years, we'll have another transition that will impact current borrowers that is important to talk about. Effective July 1st of 2028, current borrowers will have access to the existing standard, extended, and graduated plans, the income-based repayment IBR plan, which will be the only legacy income-driven repayment plan available, and the new repayment assistance program, RAP plan. New borrowers will continue to have access to the same plans, the RAP plan and the new tiered standard plan. Now, I'll go ahead and pass it over to Jessie so she can tell you more about what's happening with the PSLF program.
Hi, everyone. Thanks so much, Jessica. My name is Jessie Myers. I'm the student loan ombudsman for the District of Columbia. I sit in the district's financial regulator, the DC Department of Insurance, Securities, and Banking, or DISB. So in DC, we work every day with borrowers who have questions about PSLF or are pursuing PSLF, otherwise known as Public Service Loan Forgiveness. So we're going to quickly cover what this program is and the current status of PSLF, given some headlines that you might have seen over the past few months. Next slide, please. Okay, so what is public service loan forgiveness? So it's a forgiveness program administered by the Department of Education. The program forgives the remainder of your loan balance um, after you meet these qualifications listed below. So the main thing to know is if you're employed by a government or nonprofit organization, you're eligible for PSLF. So as you can see, there are a few different buckets of qualifications. So the remainder of your balance is forgiven after you have made 120 monthly payments on a qualifying repayment plan. Generally, a qualifying repayment plan are the income-driven repayment plans that we talked about previously. On direct loans, so we talked about, you might have FFEL loans, for example. It's only forgiven if they're on direct loans from the Department of Education, while working at least 30 hours a week on average at a qualifying employer, which includes governments or 501(c)(3)s or nonprofits. Next slide, please. Okay, so you might have seen a lot of headlines or news recently on your feed related to PSLF. A lot of those headlines have been driven by a Department of Education rule that aims to change employer eligibility. It's unclear what the future of the implementation of this program will look like. There are currently several pending legal challenges, including a suit from multiple states and DC. So, and I want to also emphasize that Ed has stated that the rule, if implemented, would impact about 10 employers per year, just to give folks a sense of scale. There's a lot of question marks here. As I mentioned, there are several pending legal challenges. What do we know? What we know is that PSLF is a program created by law. Changes are not likely to impact prior history, so it likely won't have a retroactive lens where forgiveness is removed. I want to emphasize to borrowers that a lot of PSLF processes to today are automated. And so I'll get into what this looks like, but if you continue certifying your employment eligibility, we are seeing that borrowers are still continuing to receive forgiveness through PSLF. So I just really want to emphasize that to folks of that this is something we're still seeing happening. So what does this mean if you're a borrower? A lot of that seemed like a lot of question marks. Like, what does this actually mean? What this means is keep certifying your employment. Use the PSLF help tool. I'll throw a link in the chat where you want to certify any eligible employment that you might have. So if you're currently working for the government at a nonprofit organization, any periods of public service employment after October 2007, we highly recommend that folks go in and certify that employment. All you need for an employer is you need the EIN number, which you can find on your W-2 or talk to your HR folks about, and a email to be able to send the verification to someone within your organization. Thank you, Margaret, for sending that in the chat, who can verify your dates of employment with the eligible employer. So that's the big takeaway for folks who are pursuing PSLF right now. Next slide, please. Yay, thank you so much. Quick note on PSLF buyback. I know this is something that Margaret had referenced earlier. If this is something you haven't heard of before, so Ed has a program where you can buy back certain months in your payment history. For example, the SAVE forbearance, which is impacting millions of borrowers right now, to make these periods of deferment or forbearance qualifying payments for PSLF. We get a lot of questions of folks who have submitted a buyback request with what the current status is. There is a significant backlog currently of unprocessed PSLF buyback requests. So as of recent numbers that we have from February 28th, Ed's backlog is over 88,000 applications. That is significant. And just over 2,500 requests were processed in the month of February. So again, talking about scale here, we're seeing a significant backlog of buyback requests. And there is currently no estimate for how long it will take for these requests to be processed. We want to emphasize that duplicate requests will not result in faster processing. So just want to flag that for folks. Again, we understand this is a lot of question marks. So what does this mean for you? This is a personal decision. We highly recommend, if you're a district resident, you have questions about this, definitely reach out to us to talk through what your options are. Generally, if you really want to make progress sooner rather than later on PSLF, you can switch to another IDR plan. And then related to the backlog we're seeing and delays and the impacts that have on you, you can file a complaint with the Department of Education, your congressional representative, or in the district's case, your Attorney General's office. If you're a district resident, you can also reach out to our office as well. So yeah, that's it on my end for PSLF. I will now hand it over to Amber to continue talking about PSLF. Thanks.
Thank you, Jesse. Hi, folks. My name is Amber Hay, and I serve as the Public Service Loan Forgiveness Advocate. I'm housed within the Office of Student Loan Advocacy at the Washington State Student Achievement Council. While there aren't firm changes happening to the program itself right now, as Jesse just covered, the changes as a result of the One Big Beautiful Bill Act may impact borrowers pursuing PSLF. So I will be covering how these changes affect different groups of borrowers. Next slide, please. Borrowers with unconsolidated Parent Plus loans who want to be able to access income-driven repayment options in the future must submit a consolidation application by April 1st, 2026. This is the deadline that we are reasonably sure will result in the consolidation being completed before July 1, 2026. Without consolidation, Parent Plus loan borrowers can only access PSLF if they stay on the 10-year standard plan, which of course may pay off their loans when they reach that 10-year mark, leading to no forgiveness. If you have already consolidated your Parent Plus loans at least once, you do not need to consolidate them again to retain access to IDR plans. Now, new borrowers who borrow any loans after July 1, 2026 must repay their loans under the RAP plan or the Repayment Assistance Plan to make progress towards PSLF. Payments under that new tiered standard plan will not count towards PSLF. New Parent Plus borrowers, Parent Plus loan borrowers, will not be able to access the RAP plan or PSLF. So again, that's new Parent Plus loan borrowers that are taking loans out after July 1, 2026. New borrowers that have both Parent Plus loans and their loans for their own education may access RAP and PSLF only for their non-Parent Plus loans. Next slide, please. For current borrowers pursuing PSLF who are not borrowing any more loans after July 1, 2026, there are some things you should be aware of, and Jessica kind of alluded to these, so I'm going to spell out these in a little bit more detail. If you are still in the Save Forbearance, start looking at other currently available income-driven repayment plans, which right now are the income contingent repayment, pay-as-you-earn, or income-based repayment. Months that are in the Save Forbearance do not count towards PSLF, but may be able to be bought back under the PSLF buyback program. If you are already in the income contingent repayment plan or pay-as-you-earn, you must move into either income-based repayment or the new repayment assistance plan no later than July 1, 2028. So you have some time to start thinking about it. If you're already in income-based repayment, you can stay in IBR indefinitely. This plan isn't going away. Borrowers will be able to start accessing the new IDR plan RAP on July 1, 2026. Now, for all current borrowers who are pursuing PSLF, we recommend that you utilize the online income-driven repayment application tool and its IRS connection in order to see what monthly repayment estimates might be right now under all of the available IDR plans. RAP is not currently in there, so we've also linked in our slides the New York's EdCap's IDR calculator. They do include anticipated monthly payment estimates under the new RAP plan. Remember that as a PSLF borrower and as someone who's on an IDR plan, you should be recertifying your income roughly every 11 months or if your income decreases. That's all for PSLF. I'm going to go ahead now and pass it over to Stephanie.
Good afternoon, everyone. My name is Stephanie Rue. I'm the Student Loan Ombudsman in the state of Maine. I'm housed in the Bureau of Consumer Credit and Protection for the state of Maine. I'm going to be speaking about default and delinquency and what each of those mean to you as a consumer. Next slide, please. So what is delinquency and what is default? Oftentimes, folks tend to use these interchangeably, not really understanding the nuances between them. But it is important to know when it comes to student loans and what will happen to you if you do not rectify your situation. Delinquency is when a loan becomes delinquent for the first day after a missed payment. It can result in potential late fees after 30 days and negative credit reporting after 90 days, which is 3 months. It is important to note folks are just now in the past year or two realizing the effects of their credit impact of being delinquent on their loans. During the COVID forbearance, there was no negative credit reporting whatsoever. And when that ended in September 2023, individuals were given a grace, which was referred to as the on-ramp period, until the end of September 2024, that they wouldn't be reported if their loans were delinquent at any point. It is important to note if you were delinquent at the end of that on-ramp period, the reporting would be reported as delinquent. Negative credit reporting, it can impact a number of things on your credit, such as, with late or missed payments. It impacts on every possible level of your life. It's not just a piece of paper with a number. It impacts your ability to access future loans, obtain credit cards, a potential home, even a job. When you have a background check and a credit check on your new employment, that could deem you ineligible for that position. So default. This is something that we've heard about recently. In May 2025, the administration decided to resume involuntary collections on defaulted student loans. So if you miss payments on your student loans for more than 270 consecutive days, so 9 months, your federal student loan enters into a default. And that is an important distinction going forward. Next slide, please. So why you should care about default. It's important. It's not, again, not just being past due. They accelerate the entire balance of your loan. It's called immediately, and you will owe everything, including fees. You become ineligible for all the options that are the perks in federal student loans, repayment plans, forgiveness, deferment, and forbearance. All that goes away. You're unable to get future student loans, federal student loans. That will prevent your ability potentially to go back to school or continue your education. Your tax refunds can be offset, which means when you file your taxes, if you owe this amount in a defaulted status, they will take that from your tax return. And that is perfectly legal. And I will make note at this point, in January, mid-January, I believe the 16th, the administration announced that they would be delaying that implementation of the involuntary collections, such as your tax refunds being offset and wage garnishment, which is the next section. They can garnish your wages up to 15%, again, having a significant impact on your household income, daily life, really. Obviously, as we spoke before, negative credit impacts And you could be taken to court. Collection, attorney's fees, court costs, anything that's associated with taking that action against you may be charged to you, and those can be significant. Next slide, please. Excuse me. So you have a loan in default. What are you going to do? So we all know that they agreed in May that they would start these involuntary collections. So letters started going out to folks, which was very disturbing to most. We've all received phone calls. I've gotten this letter. What do I do? It's important, first and foremost, to contact your servicer and let them know you're aware of the situation and what can you do about it. And there are some options. Generally, you can consolidate your loan, repay the defaulted loan with a new direct consolidated loan, or you can do what's referred to as rehabilitate your loan. What that means is you would enter into a written agreement with the loan holder and pay 9 reasonable monthly payments on time in full within 10 consecutive months. That is a one-time opportunity, so it is important that you make it work. There are trade-offs with these options, obviously. And we do have a more detailed resource with the link that's provided on the screen that goes into that, depending on what kind of loan you have, what your history looks like. There are some nuances in that, but that is definitely some good resource material for folks that are facing a loan in default and want to get out of that default. Next slide, please. I'm going to turn it over to Lane Thompson out of Oregon to discuss your borrower rights and responsibilities. Thank you.
Thank you, Stephanie. Hi, everyone. Lane Thompson. I'm Oregon Student Loan Ombuds. I sit in the Division of Financial Regulation here in Oregon. I want to start off with just a quick deep breath. This is a lot of information. As consumers, as student loan borrowers, what we have done is entered into a contract with an entity, right? Next slide, please. So I just want to touch really quickly on some of the rights and protections that you have as a result of entering into that contract. These do vary by state, so I would recommend, finding your state's website if we have one, kind of doing a little research to find out which of these pertain to you and exactly how. There are some federal protections as well. Some of those are included in the Dodd-Frank Act that was passed after the 2008 financial crisis. Some of the basic things that servicers are expected to do based on their contract with the Department of Education and based on your contract with them is to post loan payments timely, provide accurate information, process your paperwork, and respond to complaints through our offices within timely manners. One thing we didn't talk much about today are total and permanent disability discharge or borrower defense to repayment. Those are examples of some of the additional protections that exist for folks who have certain identities and certain life experiences. Some of these rights and protections, the state ombuds and advocates can help you advocate for. Some we cannot. Some states allow a private right of action, and hiring an attorney is often, a step in this process. As ombuds, we are not able to provide legal advice. We are not your attorney. So while we are here to help, we also want to make sure it's clear what role we serve. Next slide, please. I also just like to touch on responsibilities. The main responsibility I always say is knowledge is power. So if you can know who your servicer is, what type of loan you have, and how much you borrowed, and how much you might have to repay, right? Because it's going to be a lot more with interest. I always recommend that folks see if their servicer is licensed. A lot of states require student loan servicers to be licensed. All your credit information, it's really on borrowers to have that information correct. So if you're seeing issues there, you're encouraged to reach out to your servicer, reach out to the credit reporting agencies. You are required to repay these loans regardless of graduation status. This is, as I mentioned, a financial product, a contract you entered into. One of the big kind of responsibilities you have as a borrower is to educate yourself about them. So I really just want to give you all a round of applause for attending today. Good job on educating yourselves. In order to kind of pursue some of these rights and make sure that you are able to access all of your rights, you have some options, which include submitting complaints through the Consumer Financial Protection Bureau or the U.S. Department of Federal Student Aid, FSA, or through the states represented on this call or the other states who have advocates and ombuds. Next slide, please. With that, I will pass it over to my esteemed colleague from Minnesota, Jabra.
Thank you, Elaine. Good afternoon, everybody. My name is Jabra Kawas. I'm with the Minnesota Department of Commerce, the student loan advocate. So my office is housed in the Department of Commerce. And I'm here to talk about some resources for you. Next slide, please. Typically, when people reach out to my office, I will always ask, have you reached out to your servicer? I encourage people to make that your first stop with questions, concerns. That is going to be kind of the where you're going to get the basic information that you may need. After that, what I encourage people to do is then reach out to my office, or if you have an ombuds or an advocate in your state, reach out to them. Servicer information can be found on your FSA online account. If you're unable to obtain information in a timely manner, get resolutions, that kind of thing, next stop would be state government. So like my office or any of the other ombuds and advocates on the call today. If your state has a ombuds office, reach out to them. We're here to help. We want to help where we can. And like Lane pointed out, the same holds true for my office. Can't offer legal advice, can't offer financial advice. However, a lot of the issues that I'm seeing, and I think I can speak for my colleagues, there are things that we can assist with, and what I like to advise people is like, if I can't assist you, I will at least try and point you in the right direction. Not all states have someone in these roles. I think there's about 20 of us or so that leaves another 30 states without, or 30, roughly 30 without anybody in this role. You can reach out to the Department of Education through federal student aid, and questions, complaints can be submitted to their feedback center, as well as any escalated issues too. If you have escalated complaints, escalated concerns, things that you may have already raised with another organization, entity, the feedback center is a good place to go. And then for private loan complaints, as you know from earlier, there's a difference between federal loans and private loans. You can file a complaint with the CFPB, the Consumer Financial Protection Bureau, which I think Lane referenced in her presentation. Next slide, please. We just heard about defaults, and if you have defaulted on your student loans, federal student loans, one of the resources you have is the default resolution group with federal student aid. They oversee collection process for all defaulted loans that are held by the Department of Education, so federal loans. And then we also heard a lot today about public service loan forgiveness. Questions about the status of your forgiveness. Your servicer, once again, should be the first stop for any questions. I know it can get confusing. A lot of rules, a lot of rule changes upcoming. So first stop, servicer, not getting any resolution there. And one of the things that I'm hearing, and I think we're all hearing here, is there have been long wait times in reaching out to some servicers, lack of responsiveness. Those types of things, I encourage people then to reach out to me, to my office. And then we will try and at least contact the servicer to find out what's going on. There's some other great resources on here, links to these. There's Protect Borrowers Congressional Casework Tool, Federal Student Loans, Protect Borrowers, Student Loan Borrower Assistance. There's EdCap, and that helps New Yorkers with student loans and debt. Balanced Financial Wellness, and the TISLA Fair Free Student Loan Advice. That's it for my presentation. I am going to hand it back over to Selena, who will take us home.
Thank you, Jabra. We have all our panelists' contact information on the screen. Just a reminder that you will receive a copy of this presentation with links, all the resources. There is a link to a list of all your ombuds, your advocates. And so we would love to hear from you. We want you to contact your advocates. We want to hear from you. We are here to help you, even feedback for future webinars. If you're a borrower that doesn't have an advocate, a bill of rights, that doesn't have an agency, I'd encourage you to communicate with your state representatives. I know information was given on that, and to really let them know that your situation. Also, talk to or communicate with advocacy organizations because they want to hear borrower stories. They want to hear what you're facing with servicers, whether it's lack of responsiveness from either entity, whether it's a servicer or Department of Education. Those stories are really important, and we know that you are encountering challenges. So we hope that we've given you resources, links, at high level information, and now you can go ahead and contact whoever you need to for assistance, read up on the information, and really start planning and see how these changes are going to affect you. We are at the end of our webinar. You will be receiving a copy of this presentation, and I want to thank you all for joining us today. Again, I know it's a lot of information, but please stay in touch, and thank you to my panelists, and we hope you have a great rest of your afternoon.